A wife or a legal spouse could ask for a portion of the estate, while a girlfriend or boyfriend could only ask for maintenance. A legal spouse, under Cap 481, could apply to the court for an order on the grounds that reasonable financial provision has not been made from the disposition of the estate, while a girlfriend or boyfriend could only rely on the fact that they were being maintained by the deceased either wholly or substantially prior to the deceased's death. And also, they could only apply for reasonable maintenance. This could be contrasted to the position of a legal spouse, where there is no requirement to prove that there was maintenance either wholly or substantially prior to the death of the deceased.
Reasonable financial provision under Cap 481 varies depending on whether or not the applicant is claiming as a spouse. If the applicant is claiming as a spouse, his or her claim is not restricted to reasonable maintenance. It is what is reasonable in all the circumstances, whether or not that is necessary for his or her maintenance. On the other hand, if we're talking about an applicant in another category, for example, a boyfriend or a girlfriend who was financially dependent on the deceased immediately prior death, then his or her claim would be restricted to what is necessary for his or her maintenance. So that would be referring to his or her day-to-day costs such as accommodation, food, travel, etc.
Whether a former spouse could make a claim under Cap 481 would depend on whether such entitlement has been excluded in the divorce proceeding. A former spouse or former wife or husband, if they have not remarried and were being maintained either wholly or substantially by a deceased immediately prior death, could make an application to the court for an order to make reasonable provision required for maintenance. However, a court during the divorce proceedings could make an order to exclude the parties from making such an application. If so ordered, then both parties would not be able to make an application under Cap 481. Where the decree absolute has already been issued, but financial proceeding is still ongoing, the court could, for the purpose of a Cap 481 application, treat for the purpose of this application that the divorce proceeding has not been made absolute. In that case, the applicant could be treated in this application as a spouse, and there would be no need to prove financial maintenance immediately before the death of the deceased. And also, the applicant could apply for financial provision whether or not reasonable for maintenance.
The ordinance does not draw a distinction between a child born out of a valid marriage and a child born out of wedlock. Section 3 of the Parent and Child Ordinance makes it clear that unless a contrary intention appears from the legislation, then no distinction is to be drawn between a child born out of a valid marriage and a child born out of wedlock.